All right. Good afternoon, everybody. Thank you for joining us today on our webinar on custody issues in the early childhood program. I hope everyone is having a good week. I don't know about y'all, but we're having Halloween carnivals and Halloween festivals and insurance open enrollment and everything all in the same week. So kind of crazy, but I'm glad to be here on the webinar. I decided to do insurance open enrollment the same week as Halloween because, I figured it's scary enough. We might as well just throw it in there. So awesome. Hopefully everyone got the handout for today's session. If not, you can download it off of your control panel over there. Otherwise, you can just kind of take notes. I'm sure that this is going to be a session that we will have lots of questions. So you can either type your question over on the control panel, or you can unmute your microphone and ask the question so that everyone can hear it, whatever is best for you. We're going to talk a lot today about what the law says, what the courts say, and kind of where our legal rights are. And just really kind of focus on what we need to be doing in our early childhood programs that's in the best interest of the children, rather than what's in the best interest of the families that are going through the custody situations. Sometimes we have to remind our parents that we are here for the children. We are here to provide quality care and education for them, rather than getting involved in their custody situations. We have to keep in mind also that over 70% of the children in this country have some type of court order or custody agreement on file. So that's a pretty large number. And if you kind of look at that and you make the assumption that over 70% of the children enrolled in your program have a court order on file, it becomes very, very overwhelming. So, this is where it's a little bit different nowadays than it was, back in the late 80s, early 90s, et cetera, where you might have, 1, 2, 3, or 4 kids in the program that have a court order. Nowadays, you can probably count on one hand the number of kids that don't have a court order on file. So, with that being said, you really kind of have to take the stance that your early education program prefers not to get involved in custody issues. And on your handout that I gave you, I kind of cut and pasted a sample policy at the bottom of the handout that kind of says that exact same thing. What I like to do whenever we are registering families for the first time, if it does become apparent that there's a custody situation, I think that is a nice time to, professionally and compassionately explain to them that we are here for the education of the child, and that it's very important that they handle their custody situations at home. And I do like to do that right off the bat, so that if you are, getting some drama, having some comments being made, you can refer back to that very first conversation. So, kind of going over to the handout, kind of basic, training right here. Everyone on this webinar knows this, but how many parents does a child have? Well, there's a sperm and there was an egg that made that child. Somewhere out there was a sperm and there was an egg that made the child. Now, yes, you could have a situation where it was an artificial insemination or a single parent adoption. Or these days we are starting to see more and more situations where a female has a baby, she has no idea who the father is, and no father's name is listed on the birth certificate. So we're starting to see a lot of situations like that. However, even though there is no father's name listed on the birth certificate, there could still be some legal drama in those situations if something was to come up later on down the road. And I'll be sure to go back to that and to make comment on that when the time is due. All right. Now, again, it is not our role, or we are not in the position to make any type of judgment or opinion on a custody situation. That is up to the court, and we need to keep that at the court level. Our responsibility is to the children to provide quality care and education for them, to provide balance for them, and that's kind of how we want to keep it. So again, the sample policy that we have down here, we prefer not to get involved in these type of situations. Otherwise, like I said, it could become very overwhelming. You know, the other thing, I just got a phone call a couple of weeks ago from a school that was having a custody situation with some parents. You know, and I had a conversation with the director that, you know, there's two sides to every story. There's actually three sides to every story. You know, this side, that side, and the truth somewhere down the middle. So, you know, sometimes when we have a parent or a guardian coming in telling us about a custody situation, we have to remind ourselves that we're only hearing one side of the story. That, you know, there's other things going on in this situation, and people tend to tell us what they want us to hear, not everything that's going on. Okay, so always kind of keep that in mind right there. Now, bullet point number 2, or number 2 on your handout, is probably the most important thing that you need to take away from this training. So if you have a highlighter, highlight that one. If you don't have the document in front of you, take notes right here. But in the state of Texas, parents have a right to access their child at any time. And under no circumstance can you ever prevent a parent from picking up their child or releasing a child to a parent. So with that being said, when you do have a separation or a custody situation, in the absence of a court order, both parents have equal rights. Okay, and that is incredibly important. I would put this in your parent handbook. I would put this on your tuition agreements. I would put it on as many places as possible so that parents understand this. But in the absence of a court order, both parents have equal rights. Meaning, if they have not gone to court yet, both parents have equal rights. If there is not a protective order on file, both parents have equal rights. If the parent have gone to court and there is a court order on file, but a certified copy has not been presented to you, at that point, both parents have equal rights. All right. It's really important when you handle these type of situations that, you know, you do kind of put your big boy and big girl panties on, and don't let the parent who's going through this situation bully you into doing something that's going to get you legally in trouble. I know that a lot of times when we do have custody situations, one of the two parents will come in and demand that the other one not pick up, or demand, you know, this or that. You stick to your policies, you stick to the law, and if it becomes an issue, there is absolutely nothing wrong with you telling the family, this situation is making us uncomfortable and we may have to ask you to leave. Okay, or this situation is making my staff uncomfortable. I cannot have my staff uncomfortable. You may have to find other care. And like I said, we do want to be compassionate and we want to help the families out, but we don't want to get in the middle of it. That's the biggest thing. Now, we've got a couple of different types of custody situations that we need to be aware of. They're pretty plain and simple these days. Again, this is such a different topic than it was back in the 80s and 90s, where every single court order that we had on file was a little bit different. These days, most of the court orders, 95% of the time, they are standard fill-in-the-blank documents, where the courts will have a standardized document. The judge goes in there and they basically fill in the blanks. So you don't see a lot of weird stuff like we used to. You could have a shared or joint custody situation, or you could have a sole or exclusive custody situation. Most of the time, you're going to see a shared or joint custody situation. I will tell you that in my experience, anytime you do have a sole or exclusive custody situations, half of the time you will also have a protective order that will go with it. Not all the time, but most of the time there's something else that goes along with that. All right. Now, any court order that is brought into your program by a family member needs to be a certified copy from the court. It cannot be a photocopy that they make on their copy machine or your copy machine. Those are not valid. They have to be a certified copy. And the parent who's going through the custody situation, their attorney can easily get them as many certified copies as they need. All right. Now, what I encourage you to do on this one is that when you do get a certified copy of the court order, the only thing we want is the part that pertains to the child. Okay. I don't care who got the house. I don't care who got the boat. I don't care who got all the bills. Just give us the part that pertains to the child. That's the only thing we need. I would go through there with your highlighter, highlight what you need to know, and then put it in your confidential file in your children's records. All right, educate your staff if there are any type of restrictions or exclusions. Educate your staff, but then also come up with a plan that if there is a situation that violates one of those exclusions, how it's going to be discreetly handled. For example, if it says something like dad is only allowed to pick up on Wednesdays and every other Friday, and dad shows up on Tuesday, we don't want our teachers being the one to tell dad, hey, you can't pick up. That needs to be something that's handled by administration, and it definitely does not want to be handled in front of the children. So work with your team, figure out a discreet way that you're going to handle these situations. Now, let's say you do have a situation like I described where dad is only allowed to pick up on Wednesdays and every other Friday, or whatever your situation may be. All right. Mom at that point cannot call up on Tuesday and say, hey, I like dad this week. I want him to pick up Tuesday night. Mom does not have that authority to make that phone call. The only one that can change a court order is a judge. Okay. So if you have a court order that is very set in stone, this is how it is, then that's what you follow. Okay. Now, I told you earlier that most of the court orders these days are standardized documents. They're all fill in the blank. Most of your court orders in a shared or joint custody situation will say something like, dad is to pick up on Wednesdays and every other Friday unless both parties mutually agree on a change. And that's your golden ticket right there when it says, unless both parties mutually agree on a change. In that situation, it's pretty much a wide open ball game. All right. Otherwise, the only person that can change that court order is the judge. Now, a lot of times, one of the biggest issues that we run into with court orders is an issue where dad sends his new girlfriend to pick up the child, and mom doesn't want the new girlfriend to pick up the child. And we get into this whole battle over who can pick up and who can't pick up. So this is a very part of the court order also. It's not so much, just who has possession of the child. It's also who can make decisions for the child or based on the child. And you can see here on our handout, such as health, education, religion, culture, creed, all of those type of things. And 9 times out of 10, you're going to see the court order will say both parents have a right to make decisions based on health, education, religion, culture, etc. All right. So when you have that in there, okay, then mom can add whoever she wants to her pickup list. Dad can add whoever he wants to his pickup list in the story. All right. If mom has an issue with dad's girlfriend picking up, they need to handle that at home. Okay. And again, we kind of have to put our big boy and big girl panties on and say that in a nice professional way. Hey, you know what, mom? You and dad need to take care of this at home. Let us know what you decide. All right, but don't let them put you in the middle of it. It's pretty simple. It's hard, and trust me, I know it's hard, but stick to your guns on that one. Now, it is really important for several reasons, not only the protection of the child, but for your protection, that when you do have a family come in to enroll a child, that every single line is filled in on that enrollment form. They need to give you all of the information about the child, including mom's name, address, phone number, dad's name, address, phone number, however the situation is. Even if they say dad is not in the picture, we still need the latest information on dad, whatever they've got. Dad could walk in, or mom, depending on the situation, could walk in at any point in time without notice, show a birth certificate and a picture ID proving that he is the father, and legally you cannot stop him from taking the child. All right, now, of course, you're going to jump on the phone. You're going to notify mom. You're going to try to stall him as much as you can while, mom gets up there or whatnot. But that's why, again, it's very important that you have, all of the information. I would strongly encourage you that you do not accept a child for enrollment unless you have all of the required information. Don't let them leave spaces blank. All right, that is going to cause problems for you. I had a mom tell me one time that dad was dead. So, I said, I'm so sorry for your loss. I bet that was very sad for both you and little Johnny. I still need you to write down dad's name and write deceased next to it. I finally got her to do that. 6 months later, you guess who comes walking in the door with mom? It was dad, after she had told me he was dead. So at that point, we de-enrolled the family for falsifying a document. Okay, so it's really important that you do get that. Um, these days you may also want to consider altering your enrollment form or your admission form to where it doesn't necessarily say, mom and dad, but it may say something like responsible party one, responsible party two, and then having them define the relationship to the child. These days, again, where you've got so many situations that it could be a mom and a stepdad, it could be a dad and a stepmom. I can't even tell you how many families I have that are grandparents who have legal custody of their grandchildren. So it could be a grandma and grandpa. We've got several situations where you've got same gender couples, so mom and mom, dad and dad, however it falls. There's just such a huge variety these days, and we want to be respectful to all of our families. We want to be accepting to all of our families, and sometimes we can insult, certain groups very unintentionally just by making the assumption that it's a mom and a dad. So you might want to think about that: responsible party one, responsible party two, and then having them define that role. Because that kind of leaves us to another part of this custody situation, where, step parents and grandparents do not have any legal rights unless you have a court order stating otherwise. All right, it's not my rule, it's the law. So don't shoot the messenger. But, step parents and grandparents have no legal rights unless there's a court order stating otherwise. So sometimes if you do have your enrollment form where it just says mom, it just says dad, I've seen it 100 times. Well, they will list out mom and all of her information, and under dad they'll put stepdad's name and list out all his information. That's actually considered falsifying a document because that stepdad is not dad, and it could put you at legal risk for disclosing confidential information to the stepdad who technically doesn't have legal rights. So again, this is an area where you want to protect yourself. Make sure that you're delivering the right information. All right. Now, if mom wants to grant you permission in writing to disclose confidential information to stepdad. When stepdad is dropping off and picking up, mom has every right to do that. And you want to make sure that you do get that information. I have a family at one of my schools where mom is a CPA during tax season. She's very, very, very busy. Grandma and grandpa from El Paso come down every year during tax season and drop off and pick up the little girl and take care of her while mom is super busy doing her tax work. We've known this family for, 5 years now. We have no problem having conversations with grandma and grandpa. Just got to make sure that we have that little sheet of paper from mom saying, hey, it's okay to discuss these things with them. Not that I would ever think this family would do anything, but you never know. You never know. All right. So make sure you've got all of that. Now on the visitation, again, whether it be a mom day or a dad day, unless both parties mutually agree on a change, if that sentence is not in there, then you follow the court order exactly as written. All right. Any questions on what we've discussed so far on court orders and right to release? Let me say this really quick too, because this is important when it comes to custody issues. It does not matter who enrolled the child. It does not matter who's paying the tuition. All of those things are irrelevant when it comes to custody situation. Both parents have equal rights. Both parents have equal rights unless there's a court order stating otherwise. All right, so we got a really good question. What if the father is not listed on the birth certificate? Okay, and again, this used to be something that was very, very, very rare. Now we're seeing it all the time. All right. If you have a situation where mom says dad's name is not listed on the birth certificate, first off, I'm going to get a copy of the birth certificate. All right. You have every legal right to ask for a copy of the birth certificate. I know a lot of organizations are now requiring copies of the birth certificate upon registration just because this has gotten so crazy. And so, of course, they would bring the original birth certificate in. You can make a copy of it, send the original back home with them, and then you're good to go. Now, normally, when you do have a situation where there's no father's name listed on the birth certificate, that's clean and simple. Mom has full legal rights, clean and everything. However, let's say, for example, when the baby was born, the father wasn't present. She claimed that she didn't know who it was. No father's name is listed on the birth certificate. But then months down the road, years down the road, there's a paternity test, and it is decided that, whoever is the father. Okay. Now, in that situation, this guy, who the paternity test came back and said is the father, he could walk into your program with a copy of that certified paternity test and a picture ID. And unless you have a protective order or a court order stating otherwise, he's got some, not as much, but some liability or some responsibility right there. So it's kind of scary. If you ever do have a parent that has a paternity test and it kind of does decide who the father is, you need to make sure that there is a court order behind that, all right, stating what the rights are. So that is a big, cover yourself, protect yourself situation right there. All right. Okay, so Rebecca asked the question, with the custody issue, is it a good idea to have law enforcement here if there is a parent causing problems? Okay. Oh, our friends at law enforcement, we love them. We support them. Now, you can even see in my sample policy that I have down here that in the event that a custody dispute takes place on our property, the local police will be called to handle the dispute. They used to be very helpful in this situation, and they used to be able to help us out quite a bit. We're now starting to see a lot of local law enforcement that will come up to the center and say that this is a private matter and we need to handle it. Okay. Where I'm going to then return and say this is a private matter between mom and dad. They need to handle it. Okay. And it needs to be handled off our property. Now, going on this one, and I'm going to refer back to minimum standards, where it says people whose behavior and or health poses a risk to the children must not be present. So in a situation where you've got a custody dispute and it's become aggressive, whether it's yelling or shouting or physical, you call the police department at that point. I'm calling the police not because I have a custody dispute. I'm calling the police because I have an adult who is placing children at risk. Okay, so make sure you kind of take it in that angle right there. Now, hopefully you've got a good cooperative police officer that is going to reinforce that this is a family issue and needs to be handled at home. But definitely if you feel that they're placing children at risk, they've got to go. Okay. And my whole thing is that if I ever have to call the police, it's going to be the parent's last day. They need to handle that. All right. All right, so what if there's a nanny or an older sibling that's picking up and there is an incident report that needs to be signed? Is it okay to let them sign it? From a legal, Amy, I can answer this two different ways. I can answer it from a legal perspective and I can answer it from a customer service perspective. And unfortunately, they're different answers depending on how you go. So from a legal perspective, absolutely not, because that is releasing confidential information to this individual. So in the event that you have an alternate pickup coming in, I would go ahead and give the parent a phone call and let them know of the incident, and then document the date and time of the phone call and who you talked to. And then the next time you actually see that parent, have them sign the incident report. All right. Now, what I would do if I had a nanny or sibling situation where you were not able to get a hold of mom and dad, then I would probably pull out a blank incident report, put today's date on it, the child's name on it, and then just write a note, please have mom or dad call me at this number, and then have the nanny or older sibling sign it. All right. That way, I am reporting the incident in a way, but I'm not disclosing the confidential information. And I don't know how you guys do it. I wish I had one on my desk. I don't have one on my desk right now. On my incident reports, we use the NCR duplicates where it's the white page and then the yellow page. So after they sign it, we tear it off. We keep the white page, they get the yellow page, or vice versa, however you want to do it. That way, in this case, if the parent comes back and says, no one told me that, Johnny had this scratch, Johnny had this bruise, you've got the documentation behind you that says, hey, look, here's the note that I sent home with the nanny or the sibling for you to call me, and here's their signature that they did receive it. And so that's going to be your CYA right there. All right. Great question. It's almost, it's kind of the same situation with a step parent too. Now, step parents you can make pretty clean because, again, you can get the documentation from the actual parent saying that they give permission to release confidential information to this person. You're going to be free and clear in that case. So, again, make sure that you get that. Now, just kind of going off of what the question about what if a nanny or older sibling picks up a child and there's an incident, off the subject because we're here to talk about custody situations. But keep in mind, per minimum standards, an older sibling can only pick up school-age children. So in order for an older sibling who is under the age of 18 to pick up a child, the child that they're picking up must be at least 5 years of age or older. So a sibling that's under the age of 18 cannot pick up an infant, toddler, 2-year-old, 3-year-old, etc. So again, I know that's kind of off the subject, but we all have that situation come up from time to time. All right. What other questions do y'all have on custody issues? Um, I I had a situation recently where we had an infant in our older infant room, our mobile infant room, where mom was telling us that it was okay to give the child table food. Dad was telling us that the child could not have table food. And so we ran into a conflict on feeding instructions. When mom would drop off, she said, "Oh, yeah, give him table food." When dad would drop off, absolutely not. If we did give table food, dad would start yelling and screaming that we're killing his kid. We're going to choke him. If mom came to pick up and we didn't give table food, then we were starving her child. So it put us in a very, very difficult situation. And so I had to make a phone call to both mom and dad and again tell them, hey, love you guys, love your child. We want to provide quality care and education. But this feeding situation, y'all need to take care of this at home. And I had to address to both parents that this situation was making us very uncomfortable. And again, I could not have my staff uncomfortable. I gave them till I said, y'all have until Friday to come up with a solution that you both mutually agree upon. If you don't come up with a solution by Friday, it will be your last day. And I had to be kind of stern in that situation. All right. Mom was super cool and nice about it. Dad, not so much. But he'll get over it. So, those type of things. What other questions y'all have? This topic can take like 2 hours, but I guess when we don't have questions, it goes really quick. um, awesome. Again, do not accept any child for enrollment until you have all of the paperwork on file. If they are forgetting, especially in a custody situation, all right, you've got to make sure that you have all of the information needed to protect yourself and protect your child. Be very alert when going over and reviewing this information. I hate to say this, especially on a webinar that's being recorded, but it's the honest truth. People like to hide things from us. People like to not give us the exact story. They like to give us a make believe story of something that's going on in the program. There's nothing wrong with you doing your homework. There's nothing wrong with you asking a little bit more information so that you can keep that child safe. Um, um, let me one more thing about custody situations that I want to address. And then I see a couple of good questions that are popping up now. How many times have y'all, whether you're walking as a parent, walking in as a director, walking in as a teacher, have walked into the building during drop off or pickup time and overheard a parent talking to another staff member, whether it be office personnel or a teacher, but you walked into a conversation where a parent was bad mouthing the other parent, bad mouthing the custody situation, and just going on and on and on about their custody situation. And I want y'all to think about walking into the middle of that conversation. How did that make you feel? As another parent, walking in and starting to hear some of these conversations doesn't make you feel safe. And then also, especially if it's a classroom teacher, is this conversation taking away from the supervision of the rest of the group? And are the other children hearing this conversation? I've just had to have a really tough conversation with my management team, and we had to do some role playing on this. That we want to provide quality customer service, and we want to be there for our families. But there is certain information we don't need to know about, especially if it's taking our attention away from what we should be focused on. So we kind of had to do some role playing on a polite and professional way of telling parents, hey, I really don't care and I don't want to hear about it. Say, hey, mom, you know what? I can tell that you really want to share this information. However, I really need to focus on the supervision of the classroom. Or, hey, mom, I can tell that you want to share this information, but I've got to focus on the other families, coming in and leaving the program. And that's kind of a nice way of telling them, they need to move along right there. Otherwise, we do become marriage counselors and they like to tell us everything that's going on. All right. So, not only dealing with this legal stuff and the court orders and everything, I want y'all to think about some of those other little bitty conversations that are coming in too. I got a question about sample policies that we've got out there. I do have sample policies in my childcare survival guide that's located on my website. So you can kind of take a look at that, and then you get full access to everything on a CD-ROM. So there you go. But as far as this one particular policy, I don't mind cutting and pasting it and emailing it out to you. Just shoot me an email and I'll respond to it, whatever you're wanting to take a look at. So my policies are pretty basic. I keep them really simple and clean so that the average person can understand it. If you get too complicated, then people don't understand it. So I like to keep it nice and simple. All right. Oh my goodness. This is a great question right here. How do you handle it when the court orders mom to pay 1 week and dad to pay the next? And who gets the sibling discount? Oh my goodness. That is a great question and something that we all deal with, and it is a pain, pain, pain. All right. Y'all are going to laugh at me whenever I say this, but this is what I strongly encourage. Mom and dad need to open up a joint checking account, and both mom and dad will make deposits for their portion of the tuition into that joint checking account. If you are a school that does ACH draft, then you will draft the tuition payment out of that account each week. It's not your problem how much money is in that account. It's not your problem who's paying, who's not paying. But the bottom line is that if the account is not paid, the child will be disenrolled and it becomes both parents' problems. We have way too much to do to keep up with mom's week versus dad's week versus mom's week versus dad's week. We've got a lot of other things that we need to take care of. That is the responsibility of the parents. Okay, plain and simple. Responsibility of the parents. They need to handle that. So, if I were an attorney, and I'm not, disclaimer, then that's what I would advise is that there is a joint checking account set up. Both parents make deposits into it. You do your ACH drafts right out of that account, or they write checks right off of that account for the tuition. If your system allows it, we use ProCare in my world. So even though it's a mom 1 week, dad another week, vice versa, we just have it set up to where we charge both parents half tuition each week. That way it keeps our billing nice and clean and simple, and I don't have to worry about going in and doing every other week type stuff. So, obviously when you say dad 1 week, mom 1 week, it's mom's paying 26 weeks, dad's paying 26 weeks. We're just going to do half and half, keep it simple. All right. Now, as far as who gets the sibling discount, none of my business. All right. That is between mom and dad to work that out and decide who gets the discount. And if they want to make that an issue, then it could lead to disenrollment. All right. You could easily write a policy in your parent handbook, in your tuition agreement, that says in a custody situations where parents must both make payments, no sibling discount will be applied. Okay, and that's a nice, clean way of taking care of that issue too. Yes, so we were talking about having custody conversations in the classroom in front of the children. You're absolutely right. The children listen to everything. They will repeat everything that is heard. So another reason why some of these sensitive conversations, not just custody issues, but other situations, they do not need to be done in the classroom. What if the grandparents enroll the child but are not the legal guardian? This happens quite often too. Now, again, that kind of goes back to what I said earlier. It does not matter who enrolls the child. It does not matter who's making the payment. In the absence of a court order, both parents have equal rights. If mom and dad have skipped town and they're off wherever and they left the child with the grandparents, you want to encourage those grandparents to go get a court order as quickly as possible, because it's not just us that they have to worry about. There are so many different issues that we could talk about that a court order is going to benefit them in that case. Now, if it's just a situation where mom is living with grandma and grandpa are helping them out, then of course we need them to understand that the majority of the conversations are going to take place with mom. All right. But unfortunately, that's just the way it is on that. I want to make sure we're getting some good questions now, but I do want to make sure that I cover protective orders and restraining orders. Because there is a big difference between a court order over custody and a protective order. A protective order, of course, is usually going to say something like, this particular individual is not allowed within 1,000 feet of the child or within 1,000 feet of the parent or whatever it may be. We do get these from time to time. Now, in this situation with a protective order, if the parent who is violating the protective order does show up, in that case, you do call 911 immediately. All right. The biggest thing with protective orders that you need to be aware of is that they have expiration dates, where a court order does not have an expiration date. Protective orders have expiration dates. So it's going to be very important that if you are ever given a protective order, you go in there and you highlight the expiration date. I've seen a lot of times where, for example, dad will show up to pick up the kid. Everyone starts panicking and calling the police and causing all this drama. And then come to find out the protective order expired a year ago. And dad now has every legal right to be there. And you've kind of just humiliated him. You've humiliated the kid. You've humiliated yourself. So we want to make sure that you are aware of those type of situations. And you'll usually get some type of, or the other parent will usually get some type of release that protective order has expired. But again, they conveniently forget to share that with us from time to time. All right. Awesome, Blossom. Any other questions on our custody issues? All right. And of course, you're always free to email me. You're always free to give us a call if you have any particular questions. We'll try to help you out the best we can. There's a lot of other resources that are out there to help you with legal situations, such as, childproviderlaw.com is one of the websites that I really like to refer people to, on any legal situation. The main thing, once again, is just protect yourself, protect your school, protect the child. All right. One thing that we didn't talk about, if y'all don't mind, subpoenas. All right. A lot of times in a custody situation, we will get a subpoena for documents where they want a copy of all of our sign in and out sheets or something like that. Now, of course, you have to comply. You have to provide the information. But I want you to keep in mind that you can only provide that particular child's information. So if you have a sign in and out sheet with, 20 children's names on it, and you get a subpoena for Johnny's records, you're going to have to go in, make copies of all of those sign in and out sheets, black out all of the other kids' names, make more copies of it so that it doesn't show through, and then that's what you're going to provide to the court or the attorney that's requesting it. All right. Now they are supposed to allow you an adequate amount of time to get these documents in order. So if you get a subpoena at 5 p.m. and you're reported to, expected to be at court at 9 a.m. the next day, that's not a reasonable amount of time. So you're going to pick up the phone, you're going to call the issuing attorney and say, look, not enough time right there. And hopefully they'll work with you on that. All right. Now, how about times when either yourself or your teachers get a subpoena to appear in court and testify? This is a tough one right here because it makes it very uncomfortable for all parties involved, especially if you have a situation where even after the custody case is settled, the parents are still going to be bringing the child. When you get up on stand and you testify, whatever you say could make it very uncomfortable to face that parent or the other parent in the future. So, mom and dad need to kind of understand that, we understand that you're trying to protect your child and we understand that you're trying to do what you think is best for the child. But, it could really damage the relationship that we have with the family, and we don't want that to happen. Most of the time when we get a subpoena to testify in court, it's normally going to be something like, how is the child, how do they act, what are their moods when dad drops off compared to their mood when mom drops off. That's usually what you're going to get. You may want to work with your staff or work with yourself to be able to say in that testimony, I am not trained or certified to evaluate a child, in this particular situation. I'd be more than happy to talk about our curriculum and our circle time and outside time. But as far as evaluating, documenting, and speaking on behalf of the child with their emotions and their social level, we don't have that training or certification to do that. So we don't want to put ourselves in a big legal issue by saying something that we're not authorized to say. I usually will explain that to the parent that if they do try to subpoena either myself or my teachers, that we're only going to be able to testify and talk about things that we have knowledge of, which is our curriculum and developmentally appropriate practices and all that stuff. But as far as the emotional state of the child, we're not trained or certified to speak on that behalf. And so that usually ends it right there. We don't get the subpoena. All right. Now, if you do get the subpoena, of course, you have to go. Unfortunately, you've got to go. All right. I had a case one time about 5 years ago where, I got a subpoena for myself, my director, and 3 of my teachers all in the same day. And I called and begged the attorney and begged the parent, look, you've got to reconsider this. You're taking 5 people out of my building at one time. I cannot effectively operate my business and supervise the other 200 children in this building when you take 5 people out of the building at one time. And I begged them to reconsider what they were doing. And they did. They ended up, instead of taking 5 of us, they took 2 of us, which, was doable at that point. But, sometimes you do have to have open conversations in these situations. All right, very good. All right, well, I hope everybody enjoyed the training today. I hope you got something out of it. Like I said, give me a call, shoot me an email if you have any additional questions. Your certificates will be emailed out to you here in about an hour. There was a little issue last week with the certificates. I got that fixed, and so everything should come across fine and dandy. Y'all have a wonderful Halloween week. Don't eat too much candy, and I will hopefully see everyone next week. Thanks a lot, everyone. Bye-bye.
Bye-bye. Cool. Yeah, boy.